The Honourable Annick King.
Mr Chairman, Part 2 has one clause, and this clause repeals Section 34 and inserts a new Section 34 and 34A, and it clarifies the instances under which identifying particulars of a young person can be stored as intended by the Parliament. And we are talking about young people who have appeared before the youth court, who have been found wanting and have been convicted, and in fact a case has been proven against them, and they're the particulars of these young people, not young people who have never done anything, that are innocent, that are walking along the streets of New Zealand, but young people who have been brought before the youth court, which a charge against the young person has been proved, and it's been decided by the youth court that in fact there is a number of responses that they could use. In fact, there is 7 levels of responses in the hierarchy of courts' responses if a charge is against a young person and it's been proved, and there are a level of responses, and they go from quite minor through to quite serious. In fact, the most serious being sending them to the district court for a sentence. And so there is the ability for the youth court to make a decision. But the fact is the young people had committed a crime, and the ability to retain the particulars, and in this part of the bill sets out what those particulars are, is plain common sense. Why would we not retain those particulars of young people who had committed a crime and the youth court had made a decision on it? Keith Locke has said today that we should come to this bill from a judge's point of view. Well, no, he's quite wrong. We should come to this bill facing up to our responsibility to pass a law that reflects our intent. It is then up to the judges to interpret it. And what this Parliament is doing is going through a process to ensure we have a law that reflects our intent. And I am surprised at some of the comments from Keith Locke, because he was the Green spokesperson on the policing bill during the 2 years that we consulted on it. And he met with me on many occasions. And he must think again what he said when he said, he made it sound that we knew it was there and we didn't change it. If we knew we had made a mistake, Mr Locke, do you think we would have left the bill in that position? If we knew there was a mistake, would we not have fixed it? I mean, that is a nonsensical argument, that we knew there was a mistake and we didn't fix it. Of course we did not know there was a mistake in the bill. And neither did the Green Party, and neither did the Maori Party. Because if the Maori Party and the Green Party knew that it was a mistake, and they wanted to talk about it, or perhaps they did know there was a mistake and they didn't want to talk about it. I don't believe that was the case. I believe it was a genuine error and oversight. And so now we have the opportunity to rectify it so that we can proceed on in a manner that existed in the past. I cannot see why this House would not support it. And it seems to me that many of the arguments we're having here are dancing on the head of a pin, because we want to ensure that young people who offend do get the opportunities to have different orders made on them, not all sent off to the district court. We wouldn't want that. And when you look at the responses that are available to the youth court and available for young people, you can see that many of them will help young people and their families and work with those young people and give those families an opportunity to put those young people on the right path. And so I would say, Mr Chairman, that we ought to be passing this bill as soon as we can. There is nothing wrong, in our view, in taking urgency on this particular matter. We don't always agree with urgency. In fact, we think some of the urgency has been wrong and have said so. But we are talking about a genuine admission in a bill that needs to be corrected. Unfortunately, it has been used today by the Maori Party and the Green Party, as Mr Chairman, as a stalking horse for other issues. And I do think that is a terrible shame. I don't disagree with some of the points that the Maori Party, Rahui Kātini, has raised about the broader issues, but they are not the issues of this amendment. And they are issues, and there are many reports on other issues. And never did I say to Rahui Kātini today that there were 5 reports on this particular issue. I said there were around 6 or 7 reports on the overall bill that looked at many parts of it, and we consulted on them. No, I did not say there were 5 reports on this particular part of the bill. But the wider issues are worthy of a debate, but they're not what this bill is about, and it should not today be used for a stalking horse for something else. There is a time and place to raise those issues, and that is when they should be raised, not using an amendment to correct an omission as for another ploy. I don't agree with that. I think we should concentrate on the issues before us and make the amendment as soon as we can.
Call Rahui Kātini.
Mr Chair, before I go on to part 2 of the bill, I just want to